Good afternoon and welcome to the 2007 Year in Review, Recent Midwest Legal Decisions Impacting Real Estate and Construction Law. My name is David Muth and I'm the chair of the firm's Real Estate and Construction Group. I'm going to be acting as moderator for today's webinar. We have a few housekeeping items to go over before we get into the presentation. We have a lot of information to go through, so we're going to try to keep this moving as much as possible, but here are the initial things we need to talk about. We're going to be applying for 1 hour of CLE credit for those of you who are attorneys on the webinar. If you are an attorney and want to receive the CLE credit, please fill out the CLE form located at the back of the PDF copy of materials. Those can be found in the handouts panel on the webinar dashboard that you should see in front of you. Please complete the form and return it to Devin Pine, P-I-N-E. Her contact information is listed at the bottom of the document. And finally, just a couple of additional information for today's webinar. All phone lines have been muted for those who are dialing in, and also for the participants listening to audio via computer. So you won't be able to speak, you're in listen mode only. However, we do want to get any questions you have. There is an ability to type those questions in the Q&A box located in the upper right corner of the webinar dashboard. Once you hit submit, we will have access to those questions. We are going to take all the questions at the end of the webinar, but we would very much like to handle any additional questions you may have as to specific topics we talk about today, so please feel free to do that. Finally, we'd like to make you aware that this presentation is being recorded today. And then finally, we are going to send you a brief, short electronic survey after the webinar today, and we would very much value your feedback. Thank you very much. With that being said, I'm going to turn it over to Eric Van Scandel, who's going to talk about government claims and contract and immunity, actually, in the Midwest. Eric is a member of the firm's litigation and dispute resolution group here in Milwaukee, Wisconsin. Eric has a lot of experience dealing with construction defect, land use, fraudulent transfer, and government contracting, including bid protests. He also regularly conducts internal investigations to support claims and defenses. With that, Eric, I'll turn it over to you.
Thank you, Dave, and good afternoon, everyone. Talking about procurement issues and basically contracting with governmental entities in a couple different Midwestern states. And basically, governmental contracts have three different main tenets. One, when they're being let, there has to be a fair process to achieve that. Two, they have to be in writing. And usually they almost always have onerous contract terms that a contractor needs to adhere to. And three, they almost always have bonds of some sort, usually payment bonds, to be able to ensure that the contractors in fact are going to get paid. We're dealing with a little bit of each one of those issues in all of the different states here in the different cases. First up is Michigan, and this is dealing with those onerous contract terms. The plaintiff in the Apiri and Sabota case had actually, frankly, a very good case in that there was no dispute that weather delays had caused the conditions that resulted in, frankly, 644 additional days of work by the contractor. And so the contractor had a great case. The problem is they didn't read their contract and they didn't follow the claims process that was required under it. And as a result, they could have sought an extension of time. They could have mitigated their liquidated damages situation, but they didn't. Instead, they decided to file suit to be able to try and get a declaration that the $1.9 million liquidated damages penalty was not to be enforced. Instead, the court held and the Court of Appeals agreed that the contractor did not follow the contract, even though the terms seemed onerous, and the contractor lost their claim. We'll talk about a few more cases in a little bit as it relates to the contract onerous term side of things, but additionally, the process has to be fair to be able to get the contract. Minnesota is really the only main case that we had this last year in the Midwest that dealt with the procurement side of things and in fact actually getting the contract. And I'll be honest, they went pretty far, farther than I expected any jurisdiction to go in the past. And really, we have a case that's been going on for a long time. It started back in 2012, where a contractor was working with a municipality for decades. Finally, they lost their contract, appealed it, protested it, lost again, waited 5 years for the contract to come back up. And in that new procurement, the same people that had reviewed the process the first time around were reviewing it again. There was no actual bias found at any point whatsoever, but the Court of Appeals decided that there was an appearance of bias, and that was sufficient to be able to render the entire procurement unreasonable. So the takeaway here is that it's very possible there's going to be a more ripe situation to actually protest awards in Minnesota going forward. In Missouri, they have followed a lot of other Midwestern states to effectively put further limitations on contracting with the government by labor unions. With none other than Governor Walker on hand for the signing, Missouri put in effect really a prohibition on requiring union contracting in all the government contracts going forward. That's both state and local. A PLA, which has been barred, is effectively an agreement between a contractor and a subcontractor and a trade union that those unions are going to be used for a particular project. The takeaway now is that likely PLAs are just not going to apply anymore because the contracts are going to be too expensive for those particular contractors making their bid. Going back to the contract terms side of things, this is actually a move in the direction of the contractors in Missouri, and that is an extension of the Spearin doctrine to really apply to applied warranties under the contract. Spearin doctrine is about 100 years old now, and it was a federal case that said that if plans and specifications were defective by the owner themselves, the contractor basically has a get out of jail free card so long as they actually adhered to the plans and the specs in the first place. In Pennsylvania, the contractor turned Spearin into an affirmative claim and saying that even though there was no express representation in the drawings itself, since the contractor followed the plans itself, the court said a contractor should not be penalized for doing exactly what he was required to do under another's plans. In other words, the owner takes the fall, though they could sue the design team if they really wanted to. It took 16 months longer to complete the project in Pennsylvania than was originally anticipated, and the contractor got their extra costs out of it. Missouri also dealt with bonding. And the bonding issue in the Septagon case is that Septagon contracted with an entity, Mamtech, that was a developer. Mamtech was really getting all their funding through several different deals with both the development authority as well as the municipality themselves. The contractor attempted to claim that the developer was effectively a contractor under the bonding statute 107.170, and that requires payment bonds between a public entity and a contractor. Well, the contractor here lost, and the reason they lost is because Mamtech was just a developer. They weren't what's actually classified as a contractor under Missouri law. The definition of contractor requires that that entity is providing construction services. Here it was just a developer. The takeaway, and it's kind of tough to deal with this situation for contractors, but you really need to know who it is that you're contracting with. And it's best to be able to understand that when you're entering into the agreement, because in this circumstance, there were lien rights that could have been asserted, but the contractor went after the bond, the idea that there should have been a bond there, and they did not have the opportunity to be able to sue the government for that purpose. We'll see another case later on that talks about that as well. Missouri also dealt with the onerous terms of contracts, but that they additionally need to be in writing. Work done, even if in good faith, but not pursuant to a written change order, may not permit recovery. That's what was seen in the hearing case, and also what is effectively stated in 229.050 sub 5. You've got to get written change orders. Everything has to be in writing with the government. If it's not in writing, it's just frankly not going to be enforceable. In Ohio, we're going to be talking about this case a little bit more on the lien side of things as well, but this is going back to the same bonding issue. And what I mean by that is you need to understand whether or not there is going to be a bond in a contract that you have with the government. Under the Ohio case here, the municipalities are not immune if they frankly fail to actually get the bond that's required. And a lien then, a suit could be filed against the government for failing to have done that. Wisconsin has similar case law on this same type of issue. This again goes back to the takeaway being know who you're contracting with, know whether a bond's in there in the first place before you move forward. Finally, Wisconsin also dealt with a different issue in terms of those three things that I talked about in the first place, and that is immunity for contractors when they're working on a construction project. In particular, in Wisconsin, there is becoming a body of case law that protects contractors under the governmental immunity. Here, the contractor followed the design specs exactly to a T. They had very little, they had only about, I think, 3 millimeters of separation in terms of what they could or could not do. And they severed a sewer lateral. Well, the local homeowners that got sewage into their property decided to sue on that basis. The contractor got out of it in this circumstance because they were doing exactly what the government asked them to do. With that being said, that is the governmental side of things, and I'll turn it over to Charles Harper in Chicago. Actually, I'll turn it back to Dave first. I'm sorry.
Thanks, Eric. I think the key takeaways when looking at construction and real estate projects with government entities is that there are special rules, there's special defenses, and there's traps for the unwary if you're not prepared for them. And the kicker on that is it can change depending on which state you're in. And even when you're comfortable, you know the rules change annually from statutes to other regulations to court interpretation. So it's important to make sure that you're staying abreast of what's going on in the jurisdiction you're in. Very esoteric rules at times. Speaking of esoteric rules, Charles Harper is going to jump in and talk about a statutory creature involving construction liens. Charles is one of the core members of the real estate and construction litigation group in Illinois in our Chicago office. And Charles has represented numerous developers, contractors, manufacturers, lenders, and owners in all types of real estate and construction litigation. Charles, with that, I'm going to turn it over to you to talk about liens.
Thanks, Dave. We're going to start our lien discussion today in Illinois, and the question presented to the Illinois Appellate Court was whether or not a subcontractor's $3 million lien for the installation of a wind energy system was lienable. And the complicating factor in this case that ultimately ended up being dispositive was that the developer of this particular wind energy system was not the owner of the land, but rather had an easement over the land. And that exclusive easement gave him the right to erect, install, and construct the wind energy system. But it also gave the developer the right at its sole discretion at any time to remove the wind energy system, despite the fact that it would be obviously very costly and difficult to do so. But because of that, the Illinois Appellate Court did hold that the installation of the wind energy system constituted a removable trade fixture, which is not lienable under the Illinois Mechanics Lien Act, as opposed to a permanent improvement, which of course would be lienable. And the court applied the three-factor test to determine if it was a trade fixture or a permanent improvement. And the three-factor test is listed there on the slide. But the takeaway here is that regardless of how large and expensive the trade fixture may be, if it is indeed that, a trade fixture and not a permanent improvement to the land, it will not be lienable. The appellate court also pointed out that it would have been an absurd result to hold the landowner responsible for the cost of the installation of this wind energy system that could be removed at any time by the developer. The contractor also urged the appellate court to consider the five-factor test from Crane Erectors and Riggers versus LaSalle National Bank. And those factors also included whether or not it was impractical to remove the item and whether or not the item was used to convert the premises from one use to another. Both of those factors would have weighed and did weigh in favor of the contractor. Nonetheless, the appellate court still determined that this installation constituted a removable trade fixture and not a permanent improvement, and therefore denied the subcontractor's $3 million lien. Now, we're not going to Wisconsin yet. We're actually going to Iowa next, and this involves the commencement of work in a residential construction project. So before July 1st of 2017, there was some ambiguity in the Iowa mechanics lien law with respect to whether or not a commencement of work needed to be provided within 10 days of the commencement of construction in order to preserve liens where there were no subcontractors on the project. And so the Iowa legislature has made a statutory amendment to now make it very clear that regardless of whether or not there are subcontractors on the project, lien rights will be lost to the general contractor if the commencement of work is not filed and the notices are not provided to the homeowner within 10 days of the start of the residential construction. In Michigan, we saw some additional statutory lien developments. The first is that the Lien Act in Michigan has been amended to require at the contracting stage that the contract state that electricians, plumbing contractors, and mechanical contractors are all required to be licensed under Michigan's Skilled Trades Regulation Act. Additionally, the Michigan legislature set up a business court for business disputes, certain business and commercial disputes, but they expressly excluded lien foreclosure actions from that. So if you're filing a lien foreclosure action in a Michigan court, you would not have access to the new business dispute court. Moving now to Minnesota, we have a question of whether or not the removal of byproduct created by business operations would fall under the Mechanics Lien Act. And the interesting point on this case is that both parties, both the plant owner as well as the contractor, agreed that the removal was essential for the operation of the facility. And the court determined that whether or not this would be lienable was a mixed question of fact and law, but ultimately the court looked at the Minnesota Mechanics Lien Act and determined that because the removal of byproduct, although being necessary for the operation of the facility, was not an enumerated activity under the Minnesota Mechanics Lien Act that would be a lienable activity. So although the contractor argued that it was necessary, that it enhanced the value of the property, that in fact without the removal of this byproduct, the facility could not operate, nonetheless, the appellate court determined that the Minnesota Mechanics Lien Act did not include this type of activity, and therefore the removal of the byproduct was not lienable. Also in Minnesota, in the case of Randall v. Paul, the court held that a mechanics lien contractor enforcing its rights under the Mechanics Lien Act is still subject to the federal law under the Fair Debt Collection Practices Act, and that even though the contractor had complied with all of the requirements and elements of the Mechanics Lien Act, that was not a defense to a claim for a violation of the FDCPA. Now, turning back to the case that was mentioned earlier, Kirk Brothers v. Truecraft Construction, another defense that was raised in this case by the municipality attempting to get out of the lien claim that was filed by a subcontractor on its public project was that the Tort Immunity Act in Ohio would prevent the lien foreclosure action from proceeding against them. And they argued that indeed this act, even though brought under the statutory lien provision, constituted a tort claim against it. The trial court actually agreed with that argument presented by the municipality that it was a tort claim, but disagreed and pointed to two exceptions within the Tort Immunity Act that it held would apply and therefore permitted the lien claim to go forward. On appeal, the Court of Appeals came to the same result, but for a different reason. The Court of Appeals actually said that the lien claim and the foreclosure enforcement was a statutory right and it was not a tort, and therefore the lien could be prosecuted because the sovereign immunity did not apply to actions that did not sound in tort. The court then went on to further say, even if it were to be a tort action, that indeed the exception under the Tort Immunity Act for statutory provisions that are permitted against municipalities would apply, and therefore the case could still move forward. Finally, in looking at Wisconsin, two important holdings out of a case, Balin Buildings v. Spirit Master Funding 7 LLC. In this case, the defendant sought to invalidate a lien claim that was filed and served on the original owner when ownership had transferred while the work was proceeding. And although there was some evidence presented that the contractor may have had some constructive notice of the ownership change, it was not established that the contractor had actual notice of the ownership change, and the court held that the lien would not be invalidated by the failure to notify the subsequent owner. Additionally, the appellate court remanded this down to the trial court for a reconsideration of whether the lien waiver in this case was a partial or a complete lien waiver. Although it was labeled a partial lien waiver and had some language talking about it being a partial waiver of the lien for certain work, it also stated that it was for all labor and materials furnished except none. So the appellate court determined that there was a question of fact that related to whether or not this was a full or a partial waiver. Interestingly, the appellate court did not address a Wisconsin statutory provision that likely may impact this decision on remand, and it is the section that's cited here in the slide that states that any lien waiver is complete unless it expressly and specifically limits to a particular portion of the labor performed. So perhaps that will be part of the consideration on remand in that case. And that concludes the mechanics lien portion of the presentation.
Thank you, Charles. I'm going to turn it over to Natalie Thomas, and I'm really excited to do so. Natalie, even though we're talking about updates in Midwest law, Natalie is a new addition in our Florida office, but we're very excited to have Natalie join the Quarles team. Her depth and experience significantly expands our abilities in our Florida offices to handle these real estate and litigation matters. Natalie is board certified in construction law by the Florida Bar, and she regularly represents contractors, subcontractors, design professionals, owners, and sureties in a variety of complex construction matters. Natalie also has handled construction licensure disputes and has experience in the drafting and negotiation of construction contract documents. Natalie is going to talk about one of the most prevalent litigated issues in real estate and construction year in and year out, and that involves the scope of how insurance applies in these matters. So with that, Natalie.
Thanks, Dave. Good afternoon, everyone. There's quite a few cases that are here for, making sure I can move this, for the insurance area. And I love Dave's cow, Charles's cow, but unfortunately I couldn't find anything for a sound for insurance. I guess I could have had someone crying in the background, but we will move into this. The first case was an Illinois case that was noteworthy, came out of the 7th Circuit. And the background basically of that was that there was a sub that was accused of failing to provide an association. The sub was accused of failing to provide adequate sealant to the exterior of a building, and there was water infiltration that resulted. The association brought a suit on behalf of the unit owners, and they were alleging property damage to the building itself, as well as they were bringing claims for the unit owners for their personal property. And the subcontractor's insurer brought a deck action basically saying that under that CGL policy that they didn't have an obligation to defend the sub or the GC in the underlying faulty workmanship case. The first thing that the insurance company argued was that the only duty that they had in this situation was a duty to defend against the damages to the unit owner's personal property, and the fact that the association didn't have standing to bring those claims. And the appellate court, the 7th Circuit agreed, and they held that the association didn't have standing to assert those owners' individual claims. But they also held, as to the insurance company's argument that the association, that they wouldn't have to defend the association's claims, they disagreed, and they said that the insurer also did have a duty to defend any damages to the building itself. So it wasn't only limited to the owners. The second issue, the court generally looked at the Illinois law that said damage that occurs as a result of a construction defect isn't an accident or an occurrence under these CGL policies because it's the natural and ordinary consequence of faulty construction. The court noted that that's the general law, but they also noted that negligently performed construction work can give rise to an occurrence under a CGL policy. And what they did was look at the specific definition of occurrence in this policy. And in this policy, it included not only an accident, but it also included an occurrence was said to include continued or repeated exposure to conditions. So the court looked at the allegations of negligence in the underlying complaint, and they held that those allegations were broad enough to encompass, and it did trigger, it was broad enough to encompass, continued or repeated exposure, and it triggered the duty to defend under that policy. The court then also looked at exclusions to see if there were any exclusions that apply, particularly the your work or your product exclusion, and noted that CGL policies usually don't cover an insured's own work. But it was also noted damage to something other than the construction project itself could constitute an occurrence. And here, the subcontractor's work was looked to be the application of the sealant as opposed to the entire building. So the underlying complaint did seek damages for injuries to the building, for damage to the building. So they did find coverage there, and they said that the complaint was broad enough beyond the replacement of just the subcontractor's work. Moving on to Indiana, I'm sorry, I'm not keeping up with this. Let me catch up. Okay. Walsh Construction, sorry about that. That was a matter of first impression in Indiana. It was well established in Indiana that between an insurer and a single insured, an insurer's duty to defend and indemnify only starts after a self-insured retention amount has been satisfied by that primary insured. Here, the question was, does an insurer's obligation to defend and indemnify an additional insured begin only after the primary's self-insured retention amount has been satisfied? So it was the additional insured that was saying that they had coverage under this policy, but the self-insured retention amounts had not been paid by the primary. It was a traffic exchange that was built. The sub agreed to indemnify the GC under the contract, so the sub got a CGL policy, and there was a $500,000 per occurrence endorsement. And during the construction, someone was hurt, and they filed a complaint. But it was basically held. The court did note that this was an issue of first impression, and it held that the insured did not owe a duty to defend or indemnify an additional insured under a CGL policy until the self-insured retention amounts had been satisfied. Moving on to Iowa, this was a federal case out of the Southern District of Iowa, and a window manufacturer was sued in multiple jurisdictions in several cases, and the court basically tried to take a sample representative and took 15 of the claims that were alleged in all those different cases and tried to come up with sample claims. And the basis generally was, the general allegations were that the manufacturer's product was defectively designed, and there was water intrusion into the building, and it resulted in third-party property damage and personal injury. The manufacturer paid out on these claims and then looked to its insurance company under the CGL policy for reimbursement, and the insurer disputed coverage and argued that there were not occurrences, that the defective workmanship manifesting and the water intrusion were not occurrences under the policy, so there was no coverage. And the court did note in this case that the definition of the occurrence in the policy included the requirement that the occurrence be an accident. Then the court went and looked into Iowa law that defined accident as an unanticipated, sudden, and unexpected event. The insured argued a couple things. One, they argued that defective workmanship in itself can't be an occurrence because it's not a fortuitous accident. The court didn't agree with that. They said that defective workmanship that does not result in third-party property damage can be an occurrence, and that's in comparison to defective workmanship that obviously results in damage to your own work or your own product. They also noted that prior precedent left open the possibility that foreseeable consequences of defective workmanship can constitute an accident. Basically, just because you can foresee what would happen if you did the defective work, that doesn't bar it. It could still be considered an accident. And the court looked at National Surety Court versus Westlake, an Iowa Supreme Court case in 2016, and they said, defective workmanship can be covered by a GCL policy. It's not just excluded just by the sake of being defective workmanship. And they also concluded that an accident can be foreseeable. You can foresee that an accident would happen as long as the accident is in fact unintended. And they tried to describe it a little bit more, saying that a deliberate act performed negligently is an accident if the effect wasn't the intended or expected result. So here they looked at it and they said the claims of the defective workmanship manifesting in the water intrusion damaged property other than the work so that they could find an occurrence under the policy, and there was coverage. In Minnesota, Interlochen Properties versus State Auto Insurance, this was a case where the contractor was sued, the insurance company provided a defense all the way through trial under a CGL policy. The jury returned a verdict, and trying to appeal it, the insurer would not issue or furnish a supersedious bond to stay the judgment against the contractor. And the contractor sued and said that they were basically breaching the coverage. And the court held that the Minnesota law or the subject policy, neither of those, required the insurer to furnish the bond in order to stay the judgment. And the court made the very fine distinction that the policy required the insurer to pay for the cost of the bond, but not to furnish the bond itself. And it explained furnishing as collateralizing the bond. So while they did have the obligation to pay for it, they didn't have to actually furnish it and still get the bond. Ohio, this case, Ohio Northern University versus Charles Construction, looked at the product's completed operation coverage. And it was a new hotel that they were building on the campus, and there was water intrusion after it was done and some structural defects. And the plaintiff brought a suit for damages for the construction. And the insurer of the general contractor basically intervened and basically said that there was no coverage and that they didn't have a duty to defend under the policy. And this particular policy required the insurer to indemnify for property damage caused by an occurrence. And here again, and of course, all these cases, as you can see, turn on, the specific language that's in the policy at issue. So it's always important, obviously, to look at exactly what it is, and it's hard to make, generalizations because you do have to look at your specific policy. But this specific policy noted that occurrence was defined as an accident, including continuous or repeated exposure to substantially the same general harmful conditions. The insured argued that the plaintiff failed to assert claims for property damage caused by an occurrence, and the court noted that Ohio law required consideration of the entire contract. So the court didn't just look at one provision, it looked at the entire thing, including the exclusions and the exceptions. And what the court focused on was the your work exclusion in the policy, and it was defined there as work performed by the insured or on the insured's behalf, like a subcontractor. And obviously there would be no coverage if it was their own work or some work done on their behalf. However, the court went on to note that there was an exception to the exclusion, and that was that the exclusion did not apply to property damage included in the property completed operations hazard. And there was also an exception to the your work exclusion for work causing the damage performed by a subcontractor. The court ended up in this case holding that there was products completed operations coverage, and it applies when the project was completed at the time the claim arose and the claim involved property damage caused by work performed on the insurer's behalf. And those are the allegations here, so the court found that there was coverage.
Natalie?
Yes.
Natalie, it's Dave. I apologize for interrupting, but just for purposes of timing, I know Kevin Long's going to talk about the Wazinski case in Wisconsin. If you want to talk about the Haley and Caitlin Woods cases quickly, that would be great.
Will do.
Thank you.
Okay. Haley versus Colby and Colby Millwork. It was a class action against a window manufacturer. The manufacturer moved for summary judgment under the your work exclusion. And the manufacturer's insurer had actually, this was the second time they moved for summary judgment, and they moved after the Wisconsin Supreme Court issued the decision in Wisconsin Pharmacal. And very quickly, the issue there in the Wisconsin Pharmacal company case was that there was a faulty ingredient provided by an insured, and it was incorporated into supplements, and it caused the entire supplement to be defective. So the court held that the damage to the tablet was damage to the faulty component itself, so there wasn't any coverage. And it was called the integration systems rule, and the court basically distinguished this case here with the defective windows in the building because the homeowners were requesting compensation for the repair and replacement of individual components for their house. So they basically limited the application of the integration systems rule to insurance issues related to the your work or your product exclusion in this context. And finally, very quickly, the last unpublished decision, which was noteworthy for a single point in Wisconsin with Caitlin Woods condo. And that case, they basically looked at the synthetic stucco exclusion. It's the first case I saw that they had done so, and found that that exclusion was valid. It was not illusory, and it barred coverage for these claims in that matter. And that is it.
Thanks, Natalie. I appreciate it. Obviously, it's one of the most litigated topics in real estate and construction. Each and every year we've been doing this. With that being said, we're going to turn to another really important topic that seems to be in the courts regularly nowadays, which is indemnity clauses. We're going to have Lars Gulbrandsen talk about that. Lars is not actually in the real estate and litigation group, but he recently argued indemnity clauses in front of the Wisconsin Supreme Court. Lars's practice primarily consists of defending product liability lawsuits. But with that being said, Lars, I'll turn it over to you.
Okay, thanks, Dave. Yeah, this is a little bit of a departure probably from the whole program here, because this isn't actually a case that lends itself to the year in review. And like Dave said, I'm really not a real estate or construction lawyer, and this isn't a construction case. But I understand that a lot of people, especially people in the construction industry, have concerns, and validly so, about indemnification clauses. So Dave thought it would be relevant to talk about this case, which in the coming year will be probably providing some additional guidance in Wisconsin on the enforceability of indemnification clauses and choice of law provisions, which a lot of people find in their contracts, and including construction contracts. And as this case will show, indemnification rules are different from state to state. So I'll say right up front, I think the big takeaway on indemnification provisions, and one, or I guess two questions Dave asked me to sort of answer here, is if I'm a subcontractor and I'm offered a contract that's got an indemnification clause in it, should I be worried about that? And the answer is yes. And then conversely, if I'm a subcontractor and I'm trying to enforce an indemnification clause, should I be worried about that? And the answer to that is yes. So it's important to read indemnification clauses, and some of these rules are, subject to question, and that's what this case is about. Our client, Cintas, performed a service where they inspected a sprinkler system, and in their contract to provide services, there was an indemnification clause, and it was a very broad indemnification clause. Ultimately, the sprinkler system in this building failed, caused a large amount of damage, and Cintas was sued based on negligence. We tendered the defense and the indemnity of the action to the company that we had contracted with, and said we're entitled to indemnification. And what ensued was a trip up to the Wisconsin Supreme Court with three real questions for the court to answer. And the first is an indemnification clause enforceable against an indemnity, against indemnity negligence, even though it doesn't use the word negligence? So just a very broad indemnification clause. If then the subcontractor in this case is sued for negligence, can they turn around and say, party that agreed to indemnify you, indemnify me, you have to indemnify me? The second question, in this case, we had a choice of law provision choosing Ohio law, and the question was, when is a choice of law provision enforceable? And that's really a hot button issue all over the country. And the final question is, when is an indemnification clause sufficiently conspicuous to be enforceable? So we're going to deal really here with Wisconsin law primarily, because this was under Wisconsin law. And the primary case in Wisconsin for determining whether an indemnification clause is enforceable for indemnity negligence is called Spivey versus Great Atlantic, and that's actually A&P. They used to run grocery stores. And in that case, the court held that, first sort of suggested that in Wisconsin you need to have an express statement for indemnity negligence to be covered, meaning it really should say, you agree to indemnify me for my own negligence, if that's what's sought to be enforced. Later on, they go on to articulate a test, which we'll bring up here in a moment, that suggests that maybe it doesn't have to go all that far. But the big question raised by the Spivey case and really raised in our case is, why do we have all these special rules for indemnification provisions? And I think the answer is there's no great reason. And a lot of states look at the interpretation of indemnification clauses really just as a contract interpretation under the construction that you would apply to the interpretation of any contract. But some states have applied, extra special and heightened standards to indemnification clauses because you're shifting liability, and the courts say there should be a heightened standard there. So ultimately in Spivey, the Wisconsin Supreme Court articulated a standard that is really pretty nebulous. And the Spivey case involved a slip and fall case where an employee of Milwaukee Dress Beef was injured at an A&P warehouse and sued A&P. A&P tendered the defense to Milwaukee Beef because in Milwaukee Beef's contract with A&P, there was an indemnification clause that basically said, anytime any of our employees are on your premises, we agree to indemnify you for any liability arising out of that. It was a very broad clause. Theoretically, it certainly could have covered this liability, but the court found that the clause did not clearly cover A&P's negligence, and instead articulated this next test for determining whether indemnity negligence is covered. And the test said, first, the Spivey court says, the general rule is that an indemnification agreement will not be construed to cover an indemnity for his own negligence unless there's an express statement. But then they go on to say that if the agreement clearly states that the indemnity is to be covered for the losses, those specific losses, then they may be covered. And if it is the clear and unmistakable intent of the parties in entering into the contract that the indemnity negligence should be covered, then indemnification is afforded. And so for that second test, really, if you have a very broad indemnity statement, indemnification provision, but there's an agreement to provide insurance or to waive subrogation, the Wisconsin courts have said the unmistakable intent of the parties must be that indemnity negligence is covered. In this case, we argue that Ohio law should apply because Ohio law is a little bit more lenient in terms of interpretation of indemnification provisions. So the issue that came up was when is a choice of law provision enforced in Wisconsin? Should the court have applied Ohio law? And the answer in Wisconsin is that parties can choose which law applies to the contract unless that contract, what they're seeking to enforce, violates an important public policy. And so the question then becomes, what is an important public policy of the state such that the court is not going to enforce an indemnification provision? And here the rule again is pretty nebulous, and this is a chance, this case that will come out probably this summer is a chance for the Wisconsin Supreme Court to clear this up. But if you read the cases, and I'm getting behind in time, so I'll basically summarize. I think the public policy rule basically says that a Wisconsin court isn't going to enforce a contract that's essentially illegal or unenforceable in Wisconsin. I mean, essentially illegal or prohibited in Wisconsin just because you choose another jurisdiction's law. The final thing to keep in mind is in Wisconsin specifically, the court has held that for indemnification provisions to be enforceable, they have to be conspicuous, and they adopt the UCC's conspicuity standards. So one question is whether that they really intended to do that. Wisconsin seems to be an outlier on this, but if you look at a lot of indemnification provisions, people aren't bolding the word indemnify or indemnification or necessarily setting it off the way you would a waiver of warranty under the UCC. And so there's an issue whether under this Dominski case, the indemnification provision would even be enforceable. So just to sum up, if you're drafting an indemnification provision or you're responding to a contract with an indemnification provision, things that need to be clearly stated is, what is covered. And specifically, if you intend to cover the indemnity negligence or you want your own negligence to be covered, you really should say that in the indemnification provision. The other thing is, the indemnification provision is a good vehicle for determining whose insurance is going to cover any loss occasioned by the work that's being done under the contract. And it's probably a good idea, at least in Wisconsin, to be conspicuous, set off that indemnification provision, use bold, use capital letters, and try and avoid ambiguity with the rest of the agreement. Have the agreement be consistent in terms of the allocation of fault and say that as clearly as possible.
Thanks, Lars. I think the real takeaway is when it comes to indemnity, virtually every contract, subcontract is going to have some type of provisions involving this. And when something goes wrong or really wrong at the construction site, one of the first things people will be looking at is what have people agreed to indemnify and what's to the extent of that indemnification. The real takeaway right now from Lars's presentation is language matters, and how you go about drafting it and how you go about putting it in your contracts matters. And the Wisconsin Supreme Court and other courts are probably going to be taking a lot closer look at those clauses as we go forward, because I think there's still a lot of confusion in the courts as to how to apply indemnity clauses, and it's usually involving quite a bit of money. So with that being said, we'll continue to wait and see what Wisconsin Supreme Court does on that decision. Now we're going to move into a completely different topic, arbitration, and that's going to be from Mike McCanns. Mike's a partner in our, like Natalie, in our sunnier offices that probably don't own a shovel. Mike's representing the Arizona office today on our Phoenix office. He's the vice chair of the firm's real estate and construction litigation group, and he regularly counsels owners and contractors on basically all manner of construction-related disputes. And with that, Mike, I'm going to turn it over to you to talk about ADR and arbitration.
Thanks, Dave. I'm just going to discuss some recent developments on ADR provisions, and on balance, there was nothing earth-shattering here, but nevertheless worth discussing. Starting first with Indiana, there was an interesting case about whether a surety can take advantage of ADR provisions contained within the actual construction contract itself, as opposed to in the bond-related documents that govern the surety. The case was Aztec Engineering Group versus Liberty Mutual Insurance Company. And in that case, a general contractor entered into a design-build contract with a sub to perform some design work on a public highway construction project. The design-build contract required the sub to obtain payment bonds for any subcontracts that it was going to enter into with any subcontractors. So a payment bond was executed by the subcontractor and multiple sureties to cover all claims for any labor performed under the design-build contract. The subcontractor then entered into an engineering services agreement with Aztec, and that agreement contained the arbitration clause. Aztec does its work, it's paid for some of it, but the subcontractor ultimately stops paying, and Aztec is owed approximately $4.7 million by the subcontractor. At that point, Aztec makes a demand on the payment bond, but the sureties refuse to pay, and so Aztec sues the sureties only for breaching the payment bond. In response to that suit, the sureties move to compel arbitration, and they rely upon the arbitration agreement, or clause anyway, that is in the ADR, that is in the engineering services agreement between the subcontractor and Aztec. In support of the motion, the sureties argue that the scope of the payment bond's terms incorporated the engineering services agreement, and because Aztec had agreed to arbitrate in that agreement, the sureties argued, Aztec should also be required to arbitrate the payment bond claims. In response to those allegations, Aztec argued that the lawsuit only involved undisputed amounts owed to it by the subcontractor, and therefore the ADR provisions in the engineering services agreement were never even triggered. In other words, it wasn't a dispute involving the engineering services agreement, it was a dispute over the payment bond. Aztec also argued that the sureties never signed the engineering services agreement and that the payment bond did not actually incorporate the engineering service agreement's ADR provision. The court ultimately ruled in Aztec's favor and denied the motion to compel. The court ruled or reasoned that the claims were not subject to the arbitration clause because the claims only involved the surety's failure to perform under the payment bond, and the court also reasoned that the sureties could not invoke an arbitration provision that was not expressly incorporated into the bond. So I think the takeaway here from a drafting standpoint is if you want parties to arbitrate bond-related disputes, you should expressly include the ADR provision in the payment or performance bond. And conversely, if you want those claims to be subject to litigation, you should expressly say in the bond docs that any claims arising out of this document will be, tried in court as opposed to arbitrated. Moving on to Minnesota. There was a statutory development of note. This involved the Common Interest Communities Act, which is found in Chapter 515B of the Minnesota's revised statutes. And as the name indicates, the act governs the creation of common interest communities, which are, of course, master plan communities with common elements, condominium complexes, and the like. The act also governs the HOAs that govern the common interest communities. Relevant to this discussion, effective August 1st of 2017, the act was amended and now requires HOAs to do certain things before they can file construction defect claims on behalf of the communities, of the owners in the community. Specifically, now, before proceeding with construction defect litigation or arbitration, the Common Interest Community Association must deliver written notice of the potential for a lawsuit or arbitration to each of the owners in the community. That notice must inform the owners of the nature of the claims that are going to be asserted and must inform the owners of how it is that the association plans to pay for the prosecution of those claims. The association must then obtain approval of a majority of the unit owners before proceeding with the lawsuit or arbitration. Despite those restrictions, the association may intervene or file a counterclaim or cross-claim before complying with the notice and voting requirements, so long as it then provides notice and obtains approval within 90 days of taking those actions. The takeaway here, of course, is that if you represent a CIC association, you're obviously going to want to make sure that you comply with the notice requirements before instituting a lawsuit or arbitration. Or conversely, if you represent a contractor who gets sued by one of these associations, to the extent that association failed to follow the notice requirements, you now have another avenue of defense. And Dave, I see we're pretty short on time, so we can skip Missouri and just go to the next slide, Ohio. Next slide. Thank you. And lastly, we'll talk about Ohio. And I think this is actually probably one of the most important cases, which just demonstrates that the parties who wait to invoke ADR provisions in their contracts do so at their own peril. This case was PS Commercial Play LLC versus Harp Contractors. And in this case, the general contractor was engaged on a public works project. The general contractor and the subcontractor signed a subcontract which contained an arbitration provision that, like so many that you've all seen, states that it was applicable in the general contractor's sole discretion. So if a dispute arises, the general contractor gets to dictate whether that dispute goes to arbitration or litigation. The project wraps up in March of 2015. The subcontractor does not get paid, and for months after the project wraps, is making demands on both the general contractor and the subcontractor, or excuse me, the general contractor and the surety for payment, and neither of those entities pay. About a year later, in April of 16, the subcontractor sues both the GC and the surety in court. In response to the lawsuit, the general contractor moves to compel a few months later in July of 2016. And the trial court denied the general contractor's motion to compel. The court reasoned that the general contractor had failed to demonstrate any intention to arbitrate the matter for more than a year after the project completed, and for over a year that it had notice of the subcontractor's request for payment. The general contractor appealed, and the Ohio Court of Appeals confirmed the trial court's ruling for the same reasons. And I think this is an important case that demonstrates that if you have one of these clauses and you're representing the general contractor, the onus is going to be on the general contractor to either, I believe, initiate the arbitration itself to the extent it wants a dispute arbitrated, and that would probably be in the form of a deck action declaring that it doesn't actually owe the money that the sub is demanding, or at the very least, it would be sending a notice to the subcontractor who's demanding payment saying that to the extent you subcontractor ultimately are going to pursue this claim, I am invoking my rights under the ADR provision to force you to do so in arbitration. Absent that, you could waive the ADR provision entirely. And that'll be it for ADR.
Thanks, Mike. Last but certainly not least, Kevin Long is going to talk about statutes of limitations and repose. Kevin's a member of our firm's executive committee. He's also an MBA trained attorney and also has a civil engineering background, which really helps out with his real estate and construction practice. In sum, because we're short for time, I could go on for 10 minutes talking about Kevin's accolades, but instead of doing that, I'm just going to hand it over to him, recognizing we're sensitive on time right now, and let him get right into the meat of the program.
Thanks, Dave. I want to apologize to the state of Missouri for Mr. McCann's disrespect of by skipping over their slide there. I want to highlight just a couple of very quick things. In one particular case that Natalie mentioned, either the Wasinski case, which for those of you who are in Wisconsin is the O'Donnell Park death case. But very quickly, a couple of other points. Statute of limitations versus statute of repose. Difference generally. Statute of limitations sets a lawsuit filing time limit based on when the potential plaintiff suffered harm. The discovery rule often applies. That means the time doesn't start to click until you discover their injury, but not always. Particularly in Wisconsin on contract claims, discovery rule does not apply. Statute of repose, discovery rule rarely applies, almost never applies. And particularly for those of you in Wisconsin, does not apply to this construction. Statute of repose, the discovery rule does not apply. Also 100.18 claims that many people want out, which is a 3-year statute of repose, discovery rule does not apply. Iowa recently changed their statute of repose rules. Be aware of that, shortening them. Those of you who practice in Iowa. I want to get right into the Wasinski case very quickly. That was a case, tragic case, where a concrete slab fell off of O'Donnell Park, which is a park near the Summerfest grounds on the lakefront here in Milwaukee, killing one individual, injuring another. It was high profile, it was in the paper, and it had a lot of very, very interesting issues that went up on appeal in a published decision. That site is in the materials. It's 2017 WIAPP 51. If you're a Wisconsin practitioner, I think it's well worth your time to pull that out and invest a half hour reading that case. It really deals with about 8 issues, and you could talk about it for a full hour. We're not going to do that, obviously. As it relates to this, I'm going to deal with the insurance and the statute of repose issues principally in this case, where the court came to what seemed like inconsistent results. They tie them together in a consistent way, and we'll talk a little bit about that. Statute of repose is 10 years. We're well beyond that statute in this case, but there's an exception where a person commits fraud, concealment, or misrepresentations related to the deficiency or defects of the real property. The Circuit Court denied summary judgment on the statute of repose, finding there was an issue of fact as to whether there was a concealment or misrep. In addition to the punitive damages questions, special verdict and the compensatory damages, special verdict asked whether one of the defendants, the general contractor or subcontractor, had, quote, intentionally concealed and misrepresented a deficiency or defect in the panel. Jury answered in the affirmative. Jury said yes. They appealed, and the Court of Appeals affirmed, the defendant's appeal, Court of Appeals affirmed, finding that 3 key facts supported the jury's finding. As-built drawings did not indicate changes made to the panel at issue and the manner in which it was actually installed. There was testimony from a former foreman of ACS that he had discussed the changes with the owner and they agreed not to put them in writing. And the foreman misled his own employees with respect to the method of installation being used. Essentially, they changed the method of installation being used. The Court of Appeals indicated that was enough to support the jury's finding with respect to the exception on the statute of repose. For similar reasons, there was a statute of limitations, not repose issue, that the county had. The county was a plaintiff, and it had not personal injury claims, but it had property damage claims and a breach of contract claim because of Wisconsin's economic loss rule. So they would have been out of luck, but for a 6-year, because of a 6-year statute of limitations. The court affirmed an equitable estoppel exception to the statute of limitations in that case for largely the same reasons based on the principles of equitable estoppel. There were significant insurance issues related in this case as well. And the insurer said, well, wait a second, if this is misrepresentation, that's an intentional act and there's no fortuity and there ought not be any insurance coverage. The Court of Appeals, both the Circuit Court and the Court of Appeals rejected that finding in a very interesting analysis. And the court said in that instance, there was a difference between the negligence in performing the work and the misrepresentation in covering up the negligent performance of that work. And doing a slip side job was covered, and the covering up of it was not. The analysis there goes into the classic Kaczynski greening pin case. Those of you who practice in Wisconsin may remember that. It's one case that we all learned various tort law principles from. They draw analogies between the facts of this case and that case in that particular matter. There are other insurance issues related in that case involving the your work exclusion as it applied to the owner of the property, which was Milwaukee County. And there's an interesting issue with respect to a breach of a duty of defense. An insurer provided a defense, moved to bifurcate, but during the trial of the matter wanted to take the position adverse to its policyholder that in fact they had misrepresented things and therefore didn't have coverage. The Circuit Court found that that was a waiver of its duty of defense. Court of Appeals reversed the Circuit Court on that particular issue. So there's a lot, and in addition to this, there were a number of punitive damages issues in that case and some evidentiary issues in the case. So it's a very meaty case, and I would encourage you to take a look at it. Last takeaways on this are just being aware of statutes of limitations and repose, and acting quickly, both in terms of analyzing defenses as well as if you're in the position of bringing a claim. Sorry for racing through this. If anyone has any particular follow-ups on really any of the topics, feel free to reach out to Dave or any of the presenters tonight or this afternoon.
Thanks, Kevin. I recognize that we went 5 minutes over, and I'd like to apologize for having this go a little bit over. It's just, there's so much material and so much important material going on and changes to the law that we wanted to bring to your attention, that we got through all of them. I do not see any questions at this point in time, but I want to reiterate Kevin's point. If you do have any follow-ups or would like to talk about any of these issues or specific questions you have that may be impacting things going on with your business, please feel free to reach out to us. Other than that, I'm just going to conclude by saying again, if you need CLE, please be sure to fill out the CLE material and return it to us. It's listed in the handout panel of your dashboard on the webinar. You're also going to get a brief survey from us. We value your input. And again, thank you very much for attending today's webinar. We hope you found it useful. Thank you.